There are thousands of cases you can find when searching forensically relevant court cases, but few manage to set significant precedents over the discipline. One case that holds remarkable relevance in judicial forensics is Frye versus the United States, better known as the first use of the polygraph test in an appellate court case. So, what does this case entail, and why are the findings so important? My name is McKenna Byrne, your resident general acceptance stan, here on the Forensic Science channel to answer just that. What is Frye versus the United States? And why do we care? On November 28, 1920, a well-known black doctor and insurance company president, R.W. Brown, was shot 4 times in his Washington, D.C. home following a verbal altercation with an unknown assailant. A .45 caliber handgun was found next to the body, and a single fingerprint was found on a brick outside of the house. The case went unsolved for almost a year when, in August 1921, the D.C. police picked up one James Alfonso Frye for the robbery of a broken-down taxi. With this incriminating evidence, they began questioning Frye about the murder of Dr. Brown as well. Frye then voluntarily admitted that he had shot Dr. Brown, following a disagreement regarding medication prices. After his arrest, however, he admitted to his lawyers that he had only confessed in order to collect the $1,000, about $13,000 today, worth of reward money, and split it with his arresting detective. There was a lot of confusion over the validity of Frye's claim, both about being the murderer and of being innocent. There is no physical evidence linking Frye to the scene of the crime, although the alibi he gave to the police regarding his whereabouts that night were ultimately proven false. Frye's attorney also tried to get his confession suppressed, as he was not aware of his rights at the time. This was almost 40 years before Miranda rights were even a thing. However, because the court already had a confession, there was no plausible alibi, and no evidence the detective conspired with Frye, the lawyers did not know what to do. Here entered Dr. William Moulton Marston, a psychologist who had invented the systolic blood pressure deception test in 1915, and was itching to promote its use in criminal cases. So when Frye's lawyers approached Marston to help prove the innocence of their client, Marston agreed to test him gratis, or lawyer speak for free. The test was administered to Frye in jail. Marston, immediately after the test, began to claim the Brown murder confession was entirely false, and James Frye was innocent. During the trial then, Marston waited in the wings, hoping to be called as an expert witness, while the judge heard the case. The judge rejected Frye's lawyer's request to have Marston as an expert witness. This is even after the presentation of Marston's scientific papers and dissertation to the case. While he had allowed psychologists to serve as expert witnesses before, the judge stated, in perhaps one of the most famous lines to come from the case, the difference here was that lie detection was not yet a matter of common knowledge. Until this common knowledge point was reached, juries would be responsible for determining one's innocence. It was with Frye's passing of the deception test, however, that the jury opted for second-degree murder as opposed to first-degree. Because of this, Frye was sentenced to life in prison. Now, why does all of this matter to forensics as we know it today? For a long time following the trial, expert witnesses were expected to follow the Frye standard. This was used to decide the admissibility of a scientist's testimony. This was based on if the mode of evidence collection was generally accepted by other experts in the field as a valid method of collection. This is why the Frye standard is also commonly referred to as the general acceptance standard. Did it stand the test of time? Not really. It was replaced by the Dauber standard in 1993. However, it was a significant and crucial first step towards the qualification and standardization of experts in a court of law. Thank you for watching this video. If you liked it, make sure to leave a like down below, as well as comment any questions you might have about forensics, and I'll try to answer those. Please check out the description box to find a full list of sources we used for the video. If you'd like to watch some of our other videos, why don't you click over here? As always, my name is McKenna. This is Forensic Science. I hope to see you next time. Bye.